to now introduce Laurel Robinson, and Laurel is the principal at Robinson Blake Lawyers, which was established in 2008. Laurel started practicing law in 1998. She was a legal secretary prior to that, but has a real passion for the law. She's worked a lot in the area of estates and legal aspects to do with end-of-life issues, as well as any other matters that might be around, I have no doubt. So Laurel is a member of our Sydney Inner West Club, so it's lovely that we've got one of our members who's able to present to you today. Laurel Robinson.
I'm here today to talk about three very important documents that we should all have: power of attorney, enduring guardianship, and a will. A lot of people don't want to make these documents. They think they've got plenty of time. Now, anyone who's had a stroke knows that your life can change in just a few seconds. And some of us have been fortunate, more fortunate than others. Next time it happens, we may not be so fortunate. So people really should think about doing these documents. You should do them preferably with a lawyer. When you go along to that lawyer, write down anything that you want to ask them before you get there, so you don't miss anything. You don't get home and think, oh, I meant to ask about that, but I didn't. It's very hard to ring a lawyer and say, oh, can I ask you a quick question? I don't want to make an appointment to come in, but can you tell me? That's almost impossible. So, and now the power of attorney, you are giving power to an attorney. They call them an attorney. I'll call it a relative. I think it's easier. So you're giving the power to a relative to handle your money, to handle your private property, so he can sell your motor car, he can sell your shares if you have any, he can sell a coin collection, artwork, anything that's personal property. The power of attorney doesn't need to be registered until you decide you need to sell your home, to go into a nursing home, and then a simple registration at the Land Titles Office, we call it today, and then proceed with the sale. Now, people wonder, oh, what if I appoint somebody and then I decide, no, I don't want that person to look after my affairs? Well, you can change your power of attorney. You tell the person who has your power of attorney, I no longer wish you to act. If that power of attorney has been registered at some stage, you have to lodge another document to notify the Land Titles Office that person's no longer your attorney, you're appointing someone else. You should always discuss with that person, do you want to be my power of attorney? Because it's a big ask. They're looking after your money. You have to be able to trust them completely with your financial affairs. They have to be intelligent to know if things should be sold or should you wait a little bit longer. They have to be able to discuss it with you, not just say, you want to sell those shares? Okay, we'll sell them. But discuss it, get some advice from a broker. Just take it seriously. One thing that amazes me, you never have to get legal advice before you sign a power of attorney as accepting the appointment. And I've always found that amazing, really. You sign it preferably in front of a lawyer, but the lawyer doesn't have to give you legal advice. But in that document, there are about half a dozen little rules that you have to abide by, that you keep your money and property separate from the person who is giving you that power, that you won't deceive, that power. You won't get your money mixed up with that person's money that you're looking after. Yes, so it's just a big trust, and what you can change it and once, twice, as number of times you need to. But if you don't have that power of attorney and you no longer can look after your affairs, a relative will have to go to the guardian tribunal and request that they appoint someone to act as your guardian and to look after your money and your personal property. And I'll just have a few notes, make sure I haven't missed anything. Can you make a power of attorney in early stages of dementia? Some people in the early stages of dementia have good days and bad days. Some days their memory is good, they can have good, sensible conversations. In that case, a doctor would need to be present if you're signing a legal document, and that doctor has to see that document explained to you, and he has to decide whether or not he thinks you understand that document and the legal responsibility that you are giving to your relative. And then he notes on the power of attorney form, I, so-and-so medical practitioner, was present when this form was signed by whoever, and I considered that he had his mental faculties and he knew what he was signing and he understood the document, or words to that effect. And then the doctor signs it and dates it, but they all must be present at the same time. So don't leave it too late to prepare your power of attorney, because you could wake up one morning and not knowing who you are. So, and then it's too late. And it should be an enduring power of attorney, not a general power of attorney. An enduring power of attorney will continue after you lose your mental faculties. So if you appoint somebody 12 months later, you lose your mental faculties, that power of attorney will continue if it's what we call enduring. And there's a provision in the document that says, this power of attorney will continue if I lose my mental faculties, or words to that effect. So just make sure that the document you're signing includes those words, because sometimes solicitors draw up their own interpretation of a power of attorney. I always use the Law Society precedent, which to me says everything it should say. That power of attorney also has a section where it says when you want the power of attorney to start. You might not want it to start immediately, or you might say it should start when I lose my mental faculties, or when a doctor considers I can no longer handle my affairs, or whatever reason. Or you might be just getting old, you don't want to be bothered. You think, oh, well, my son or my daughter can, or a sister or a brother, whoever you appoint, can look after those things for you. Yeah, I know a lot of people, their son and their daughter will go to the ATM, will draw out their money when they need money. But that doesn't come into a power of attorney, that's just a private arrangement. And appoint them jointly or severally. Now that means if you appoint two people to be your attorney, they can act together, which means they both have to be wherever you are at the same time, or if one of them's overseas, the one that's here can act on their own, so they can make decisions for you if a decision has to be made quickly, only regarding your money or your personal property. It's got nothing to do with your health. The power of attorney's got nothing to do with your health or your well-being or dental problems, nothing like that. It's just real estate or personal property or financial arrangements. Now, I'll leave time for questions at the end. The next one is the appointment of an enduring guardianship. Now, this must be made too when you've got your mental faculties, so you know what you're signing, but it doesn't come into effect until you lose your mental faculties, and then the enduring guardianship comes into being. So again, you have to really think hard about who you're going to appoint to be your guardian, and discuss it with them before you draw up the document. Make sure they want to do it. It's a big responsibility. They could be thinking of moving interstate but haven't told you yet. So, if you've got other children, you could appoint someone else. Some people appoint two people, or they might appoint one person and then appoint an alternate person in case that person doesn't want to do it or can't do it when the time comes. But then again, just make sure if you appoint two guardians, you appoint them jointly and severally, which means that jointly or severally they have to act together, or they can act on their own if one of them's out of the country or interstate at the time. That's quite important. People move around a lot, people travel a lot. And what the guardianship covers is they decide where you will live. If you need to sell your home and move into a nursing home, they will decide what operations you should have. This is when you've lost your mental capacity, right? And they might say, no, mum or dad's too old, I don't want them going through an 8-hour operation. They decide what dental care you need. They might even decide, they say, oh, well, mum always had her hair done every week. So they can say, right, we want a hairdresser to do mum's hair every week. Just little things like that, personal things. Or they might say, mum always liked the nails painted. Okay, so you make sure mum's nails are always looked after. And it's a big trust again. You have to have the person that's really going to look after you. Not, oh, we'll buy the cheapest for mum because she might not be here much longer. So it has to be, they're spending your money looking after you. So they've really got to look after you. Just because you've lost your mental faculties doesn't mean to say they can, near enough's going to be near enough for mum and dad. You know, you want someone that's really going to want the best for you and will treat you well, treat you with respect. Now, if you lose your mental capacity and you haven't appointed an enduring guardian, a relative will have to go to the guardianship tribunal and request that they appoint a guardian, and they will usually appoint a relative and not a government person. But it's better to do it while you can appoint who you want. I mean, these documents, the power of attorney and the enduring guardianship, they're pretty simple. There's not much to them. And with the enduring guardianship too, with your health, the precedent I use for enduring guardianship is a Law Society precedent, And that takes, they have a provision there that if you are really sick and you know that you don't want to be put on life support, but you just want palliative care, you want to be as comfortable as you can be. It's because a lot of people were requesting that. I don't want to put on life support if I'm going to be vegetable. So that the enduring guardianship that's been drawn up by the Law Society of New South Wales covers that. So, you know, I think that's important. So they will make sure you're comfortable. And also with the enduring guardianship, if your mother or your father or a loved one is in a nursing home or a hospital and something's happened, they've had a bad episode and a doctor's been called, being the enduring guardian, they have to tell you about that or give you a copy of the medical report. It overrides the Privacy Act, and that's what I love about it. You know, you've got no one telling you, oh, we can't give you that information because of the Privacy Act. If you've got an enduring guardianship that's signed, been drawn up properly, signed, dated, you say, well, sorry, I'm the guardian and I'm asking for that report. I would like that report. Under this document, you have to make it available to me. And I think that's a big thing. You want to know what's happening. And two, they might have 2 nursing homes. They might have a new one they want to fill up. But they can't move your mother or your father or your loved one to the new nursing home without confiding in you and saying, look, you know, we're thinking of moving your parent. Do you approve? And if you say, no, I don't want them moved, well, they can't move them. But if there's no guardianship, they more or less can do it. They probably wouldn't do it. But, you know, if you don't have that guardianship, you don't have that control. It's an important document. Now, I've also been asked to speak about wills. Again, this document has to be made when you've got your mental faculties. A lot of people don't want to make wills. They think, I've got plenty of time. Yes, I know I've got to do that. Yes, I must go and see a solicitor. But they put it off and put it off. And then one day, it just might be too late. Might be too late. If they're in the early stages of dementia and they want to make a will, and if they're having a good day, and if you're lucky enough to get the GP or a doctor to go to the hospital and be present with the person making the will, with the 2 witnesses and the doctor, all there together at the same time, and the will is with the solicitor, the will is read to the person who might be dying or they're very sick. And if that doctor thinks that that person understands that will, he knows who is nominated in the will to receive his asset, the doctor can sign the will. I, so-and-so medical practitioner, was present when this will was signed by whoever, and it is my opinion he knew the contents of the will and he understood the contents of the will. And that doctor must sign it and he must date it. It must be all done at the same time. No good taking the will to the doctor a week later and saying, oh, look, Dad signed this will, but, you know, we think he understood it. Can you put your signature on it? Because there's a lot of people in the family that will say, oh, I don't think Dad was well enough to make the will on that day. And they'll say, no, the will's invalid. He didn't have his mental faculties. But if the doctor was present and he does write that statement on the will, the court will accept it. And what the will does, it allows you to dispose of your assets in the manner you wish them disposed of, and you were giving your assets to whoever you wish, as far as usually husband and wife will own property as joint tenants. Their bank accounts will be in joint names. In that case, you go to the bank and just have it transferred into the name of the survivor. The solicitor will make sure the property is transferred into the name of the surviving spouse. You might not need to go through the expense of getting probate if everything's in joint names. When it's only in one name and there's property involved, you will have to get probate. Yeah, you start incurring expenses. And you appoint an executor of your will. Again, it must be somebody who you can trust. Someone who will make sure that the will is carried out according to your wishes, and that all the beneficiaries inherit what you are leaving them. It could be personal property. It could be, usually it's money. You can have a will saying, I leave to my grandchildren $2,000 each, and the remainder I leave to my son and daughter. You know, words to that effect. So you can state, usually if you have a husband and wife, the survivor will inherit everything if the other spouse passes away. Also, if husband and wife pass away together in an accident, or they will assume, the court will assume the eldest one died first. So the eldest one's will override the youngest person's will. Yeah. And most husband and wives do mutual wills. They're worded identical. Yeah. Again, you should discuss it with your executor to make sure they're happy to be your executor. Because they've got to make sure all the property that has to be sold is sold. If the house has to be sold, they have to get an agent to sell the house. It's quite a bit of work involved. And when now some people think, oh, well, I can get a will from the post office or the paper shop, and save some money. That's all well and good, but I've seen some terrible things where people have done that, and they either have just signed it themselves and forgot about the witnesses, or they might have signed it, had 2 witnesses, everything's good, but then they've forgotten to date it. So how does the court know when that will was made? If they make another will 2 years down the track, or they made another will 2 years before the handwritten will, the court's got to decide which one they think was the final wishes of the deceased person. And don't put your burial instructions in your will, because the will probably won't be read until a few weeks after the funeral. But then it's too late. If the deceased wanted to be cremated and he was buried, or if he wanted to be buried and the family had him cremated, it's too late to do anything about it. So make sure you discuss it with your family, what you want when you eventually pass away. It's a good thing to discuss with the family anyway. It's not a terrible subject. It's just something that's going to happen. We all accept it. The older you get, the more accepting it is, because it takes up quite a bit of your thinking. And And also, if you got a pet, you might have a pet and you think, oh, what's going to happen to the dog when I've gone? Some people will leave what we call a legacy in the will. Whoever looks after little Fifi or Bella, I leave them a certain amount of money, depending on how old the pet is, to look after the pet, make sure he's taken to the vet. When he has to go to the vet, make sure he's well fed, and leave them a sum of money to do that. You can put anything in a will, anything at all. I can remember doing a will and the person wanted to be buried with all their photos of Elvis Presley. That was a few years ago, but you can put anything in a will, provided it's legal. Marriage will revoke a will. So if you remarry after a divorce, you should redo your will. The same with a divorce. I always think, even though they say you don't need to redo your will, but I think after divorce you should redo your will. Even some couples are still good friends, and you think, oh, well, I'll change the will later. You're better off doing it before it becomes too late to redo your will. Now, lost children. Some people, unfortunately today, with drugs, children have disappeared from their families. Families have lost contact with them. They don't know where they are. Sometimes they might know they're still alive, but they don't know where they're living. Still put their name in the will as being a beneficiary, because a solicitor can go to the court and get an order that's Centrelink. Usually they'll be on some sort of payment. Centrelink will have, if you get an order from the court, Centrelink will have to tell you where they're sending the payments to. And superannuation. Now, superannuation doesn't form part of your estate. Usually with super, they'll have a little section there where you nominate a beneficiary to receive your superannuation. But I know from personal experience that nomination can fall out. They don't have it on their records. So it's not a bad idea to check with your super fund. Also, any insurance policies you have, that the nominated beneficiary is still on their records. Therefore, that money won't go into your estate. The trustee for the super fund or the trustee for the insurers will pay that straight to the beneficiary, nominated beneficiary. But if it has fallen off the records, the super fund's got no idea who you wanted the money to go to, that money will go into the estate. So it'll be shared amongst whoever is mentioned in the will, become what we call a residuary part of the estate. Intestate estates. Now, if you die without a will, there's an order that your estate will go to. It starts with spouse. If you have a spouse and no children, the spouse will get everything. If you have a spouse or a de facto and children, the spouse, de facto, if they've been a de facto for more than 2 years, the court consider that you're a married couple. So they will get the first 350,000, and that's CPI indexed every year. So they get the first 350. plus all the personal property of the deceased person, and they get half of the remainder. And any children that the deceased person had will get the remaining half. So, you know, that's why you need a will. You know, say my wife or my de facto will get everything. Otherwise, they don't get everything if you don't have a will. Unless there's no children, then the wife will get everything. Or if the children are children of the wife and the deceased, the wife will get everything. But these days they take into consideration the de facto, and children that might have come into the marriage later on. The spouse can buy the house if she can raise the funds. Now, if there's no spouse, no children, the estate will go to the parents. If there are no parents, it will go to sisters and brothers. No sisters and brothers, it will go to grandparents. And then after grandparents, if there are no grandparents, aunts and uncles. But usually it doesn't go that far. But have a will, and then you know whoever you wanted to go to will benefit. And just, I've got time for one more thing. About parents are lending their children money these days to buy houses. Now, when you lend that money, they normally just give it. There's no documentation. So really, to preserve that money, you should have some sort of loan document saying it's a loan, it's not a gift. Because if you don't have that and the couple break up, the court will look at that and they will say, oh, well, there's no loan documentation, it must have been meant as a gift. And then you've lost all that money. So your son or your daughter will come back to the family, but their partner will walk away with part of your money. Yeah. Anyone got any questions? Have I got time for questions?
I'll ask one while they're taking it around. I just want to ask the question, first of all, an enduring power of attorney and a power of attorney does not continue after death, does it? Everything then goes to...
It does with guardianship, obviously. Yeah. No, it doesn't. And if you use it, you're acting fraudulently, and that's a criminal offence.
So basically, once somebody has passed away, the decisions then move to the estate, and that would be then left to the person who was then the whatever they're called.
Yeah, that's correct. The attorney. Yeah, that's correct.
So, yeah.
Yeah.
Okay, any questions? I'm not following.
I just wondered, in terms of enduring guardianship, who decides that the person is not compos mentis anymore? You know, you have to have documentation from a GP, or how does it work that way?
Enduring guardianship?
Yes.
Who decides if they're not doing their job properly? No?
Who decides if the person who's the focus of the enduring power of guardianship has lost the mental capacity to look after themselves anymore? Who decides that?
Oh, well, it'd be a medical practitioner. Yeah. It wouldn't be a relative. They'd have to have something in writing. Yeah.
I just do one online. So in the hospital setting, doctors are often reluctant to put in writing a patient's capacity, stating its LHD policy. Is there something that health professionals can do in that instance?
Sorry, what was the question?
So in the hospital setting, doctors are often reluctant to put in writing a patient's capacity. is there recourse that other professionals can take?
So if the doctor won't certify that person as having lost their mental faculties?
Whether they have or they haven't. They won't state either way.
I might hand this over to you, Kylie, but my understanding is if the doctor won't sign for capacity, then it's going to be very difficult for somebody to get a capacity
So
verified.
I think the problem when people come into hospital is if someone's
Closer to the mic, please, Kylie.
I think the problem when someone comes into hospital, if you're acutely ill, we're not going to make a decision that can then impact you for longer. So enduring guardianship, if someone needs to get assessed for capacity, neuropsychology can do that, and then that would be a report that's written in writing. But if someone's in hospital, we're very reluctant to have anything to do with wills, just because it can change on discharge.
Thank you, Laurel, for coming today and giving this great speech. I've got a question, and it's been asked of me other times. What is the role of the public trustee? Are they independent or are they government regulated? Are they privately run now?
The public trustee, well, I don't like to say anything about the public trustee. They're expensive.
The public trustee is basically a government-run organisation, and they, like most government organisations these days, almost user pay, is what I'm going to say in regard to that. Public trustee and guardianship is two different things, and a public trustee is often the person who's appointed through your will, but a guardianship can be appointed, a public trustee is appointed to administer a will, but guardianship is someone who's appointed by the courts and by the guardianship tribunal to oversee the care and direction of somebody post an illness which they lose capacity. And there's got to be another social worker or somebody who works in health in this room who can correct me on anything I've said wrong there. Anybody else? It's okay? I've done well. That's at least a start. Can I just say that one of the main reasons we get phone calls, or one of the things that come up on our phone calls quite a lot, is the fact that people are in hospital and they've suddenly lost capacity and their cognitive abilities are not up to scratch. And one of the things that I learned very early in stroke is that it's very difficult to get past people such as Kylie or Liz O'Brien or Steve or anybody else on the ward to bring a solicitor in and get an enduring power of attorney signed. They're vigilant in protection of their patient, which they damn well should be. So it's really important that these things are put in place before an illness occurs or before you lose capacity in any way. And anybody at any age, shall I say, really needs to be looking at this. It doesn't matter how young you are or how old you are. We're all in a position where something can go wrong very drastically, very quickly. And unless these things are in place, we're going to be in a little bit of trouble, or our family is going to be in a little bit of trouble. And I had an aunt who said to me, "No, you just take all the money out of my account when I die, Michelle. That's fine." No chance I was going to do that, can I say to you? It's still there, no idea what to do with it, but I'm not taking the money out because, you know, I was certainly her carer, but I was not her next of kin. Her next of kins are nowhere to be seen, but that's not the point, is it, really?
No.
Do we have any other questions?
Got one more.
Thank you. Thank you very much. Has a divorcee, do they have a claim on the will? A divorcee.
No, well, usually they've already had a property settlement. Yeah. Yeah, no, that's why you should make a fresh will after a divorce. Same if you remarry, that will annul any will you've made previously. Yeah, so you need to make a fresh will.
My confusion is enduring guardianship, executor and power of attorney. Are they all different things, or if you have a power of attorney or an executor, are they the same thing? And does an executor have the right to be, or is automatically an enduring guardian?
No, two different documents. Power of attorney deals with your personal property and your real estate property. The guardianship deals with your health, where you live, and your dental care, and any personal care. Yeah, two, yeah. But those three documents you really need. People don't like drawing up, especially wills. Look, draw them up. Tell your executor where you put those documents so he can find them when you pass away, and then forget about it, you know. But you need them. You need them in place.
Why doesn't the government have a registry of wills?
A registry of wills. Yeah, you can register your will with the Supreme Court. I don't know how many people do it. I've never had to do it. I always give it back to the person who's made the will. I said, put it in a safe place. Tell your executor where he can find it when you pass away. You don't have to be 80 or 90 or 100 to pass away. You can be 20, 30 or 40.
Yes, she has quickly. I can't hear you, Lee. Sorry. Can't hear you.
Your house can burn down. I also know somebody that
I see what you're saying.
lodged with their solicitor, and the solicitor had the will, and they closed shop, and the will's nowhere to be found. So what happens in those cases?
Yeah, look, when that happens, if solicitors are retiring, they should ring the Law Society and tell them what they're doing with all their files and who they're handing them over to. Yeah, they should do that. They can't just put them away in a garage somewhere and forget about them. Yeah, I don't like holding on to original documents. I like to give them to the person who's made that document, and I say just keep it in a safe place. Never ever leave a power of attorney with the bank, for instance. Don't leave the original document there. They can copy it, but you take the original back home with you.
Okay, thanks very much for that, Laura. That was a great talk. So if I can just give your three sign-away things. One is you review your will regularly. Two is you have the three documents in order, which is the power of attorney, the enduring will, the enduring power of attorney and your will. And the third thing is don't leave anything with a bank. Banks just can't be trusted. That's my theory.
Their staff change too much.
Yep, they do.
They're one day, not the next.
They're there one day and gone the next. And their rules change, can I say? And their rules in regards to bank accounts change quite regularly as well. So always make sure that you know where your partner's information is, and also make sure that your executor is happy to be the executor of your will. That's so essential, can I say?
And your power of attorney, yeah, and your enduring guardian. People have to be happy to take on that task. Thank you.
Thanks very much, Laura. That was great. Thank you.